Thank you, Mr. Chairman. I apologize for running a little late, but thank you for putting this hearing together. I've long been a supporter of employment-based immigration. When Congress first divided immigration into two tracks, family and employment, this committee described employment-based immigration as a step in equalizing access to immigrant visas and opening new opportunities for immigrants without family connections in the United States. That's still true today. It doesn't matter where you're from or where you live. If you have skills that can contribute to our economy and our country, our employment-based immigration program provides a path for you to come to the United States legally. Unfortunately, our demand for labor across sectors and skill levels outpaces supply, a problem that's only been made worse by the pandemic. And our immigration system is struggling to keep pace. Per-country caps have artificially limited access to employment-based visas for prospective immigrants from countries like India, preventing workers who want to contribute to our economy from being able to do so. And our existing guest worker programs need to be updated to meet today's challenges, including the need for year-round labor in the ag sector and the sheer demand for temporary non-agricultural workers like landscaping, forestry, and seafood production. Today's hearing is focused on one potential source of highly trained workers who can contribute to our economy, individuals who come to study at our universities and other educational institutions on an F, J, and M visa. According to U.S. Immigration and Customs Enforcement, international students pursued more than 1.1 million degrees in the United States in 2021. For every year, more than 200,000 new highly skilled students temporarily join our workforce through the optional practical training program, outstripping the number of permanent positions available to them when they finish this program. I look forward to hearing about the proposals that would allow us to harness these students' skills in the longer term. And as we consider more pathways for high-skilled immigrants to come to the United States, we should not forget our need for guest workers who may not hold university degrees, but are important to our economy. I look forward to working with my colleagues to develop balanced, bipartisan policies to update our immigration system and meet the needs of today's economy across all sectors. If I can, Mr. Chairman, tomorrow marks the 10th anniversary of the memorandum that created the DACA program. I've long advocated for a pathway for our DACA recipients. They came to the United States at an early age through no fault of their own, and they know no country other than the United States. Like Dalio Larios, who we were fortunate to have with us today, they've made important contributions to our society. Unfortunately, the program was built on shaky legal grounds, which has resulted in 10 years of litigation, which has not yet even concluded. The Immigration and Nationality Act sets forth a comprehensive statutory scheme for allocating legal statuses. The DACA population simply is not covered under the statutory framework, and the statute doesn't even include a category for them. The Obama administration knew this when it created the program, but it simply chose to ignore the law and to circumvent the legislative process, which President Obama said time and time again he did not have the authority to do. But then he did act unilaterally, thus giving rise to the 10 years of litigation and the uncertainty that DACA recipients currently are experiencing. Last year, Senator Tillis and I asked Chairman Durbin to schedule a markup of a bill to provide permanent legal status to DACA recipients. We proposed the committee consider the bill through an open amendment process so other senators could offer reasonable amendments, which we expected would most likely include proposals related to border security, interior enforcement, and employment verification programs. That process in the committee would have allowed us to develop a bipartisan package that might have had an opportunity to gain the support necessary to pass on the Senate floor. Unfortunately, that request was declined. In the meantime, the DACA case continues to wind its way through the courts, bringing us closer to the day when the program is likely finally and completely struck down. Meanwhile, the Department of Homeland Security has failed to meaningfully respond to the historically high levels of illegal immigration across our southern border. In April 2022, U.S. Customs and Border Protection encountered more than 234,000 migrants along the southern border, the highest monthly total since President Biden took office. In other words, the problem's getting worse and not better. I've shared with Chairman Durbin and Chair of the subcommittee, Padilla, and anybody else who will listen, that as long as this chaos and humanitarian disaster remains at the border, it's very hard, if not impossible, for us to address other immigration-related issues. Migrants continue to place themselves in the hands of transnational criminal organizations that make dangerous journeys to the southern border. By quickly releasing the migrants into the interior instead of adjudicating their asylum claims, the Department of Homeland Security only continues to send the message to migrants who merely seek to improve their economic situation that this is a viable pathway to the United States. Today, we're talking about strengthening our economy and workforce through immigration, but the irony is that migrants who unlawfully cross the border and eventually receive a final order of removal will, by law, be ineligible to participate in our guest worker program. We need to take action to update our asylum laws and deter would-be migrants from trying to enter the United States this way. Last year, Senator Sinema and I introduced the Bipartisan Border Solutions Act, a balanced, bipartisan, bicameral bill that would create a fair and efficient process to adjudicate asylum claims. Migrants with valid claims would receive their green card sooner, and migrants who did not qualify for asylum would receive the legal certainty they need to move forward with their lives. In addition to the Bipartisan Border Solutions Act, this committee needs to give the Department of Homeland Security the tools it needs to effectively use existing legal authorities, including expedited removal. Our current lack of detention capacity has led to migrants being released into the interior instead of being placed into expedited removal proceedings. If the high levels of illegal immigration continue, we can expect to have more people living in the shadows in the future, with only the transnational criminal organizations benefiting from this arrangement. Mr. Chairman, continuing to ignore the crisis on the southern border, as the Biden administration has chosen to do, is only making it harder for us to build the support we need to grow our employment-based immigration system and our economy. Thank you for your patience and your indulgence.